Hi, I'm Juliet Samuel. I'm a columnist for The Telegraph and a senior fellow here at Policy Exchange, and this is the Agenda podcast. This week, we're recording a podcast on the Scottish Gender Recognition Reform Bill, which is part of our Biology Matters project here at Policy Exchange. And with me here to discuss it, I have Michael Foran, who is a lecturer in public law at the University of Glasgow and also a senior fellow at Policy Exchange. Dr. Foran wrote a very comprehensive policy paper, which we released last week, which had an introduction by Lord Keane, talking about the ins and outs of the Scottish Gender Reform Act, or Would-Be Act, and exactly what the legal issues were. For those who weren't following, last week the Scottish Government attempted to pass the Gender Recognition Reform Act, which would have completely changed the way that biological sex was determined under law in Scotland. But this was vetoed by the UK government in a very controversial move, which has set all sorts of angry voices ringing out in Scotland on the grounds that this would fundamentally affect reserved matters, that is, matters that are only the purview of the UK government and would also affect potentially people's rights and obligations under those powers. So the current situation is that the Act is not gone, but it's paused, and the Scottish Government now has to go back to the drawing board to consider whether it can amend this piece of legislation to get it through. So we're going to give you chapter and verse on this to understand all the legal ins and outs. And to do that, we are going to start by quickly running through the relevant legislation and the parts of it that matter. So, Michael, maybe you could start by explaining to us the Scotland Act, which is where devolved powers come from for the Scottish Government, and the difference particularly between reserved powers and dissolved powers, devolved powers, and the purpose of Section 35, which is this clause that the UK government used to stop this Reform Act from going through.
Sure. So the Scotland Act itself is a monumental piece of legislation. It's sometimes referred to as a constitutional statute because of the significant changes that it made to the way in which power is exercised across different areas within the United Kingdom. And in particular, the two main things that the Scotland Act did was that it set up the Scottish Parliament and it set out the scope and the nature of the powers of that parliament. And so in so doing, it adopted what's referred to as a reserved powers model. And so what it effectively says is the Scottish Parliament is free to pass laws, to make law in any area that it wishes, except for those areas that have been reserved to Westminster, and also subject to certain other constraints that are set out in the Act itself that are not directly related to whether or not the Parliament itself has competency, but deal with other issues. And this is where Section 35 comes in, because it's an alternative mechanism for the UK government to exercise a policy control where there might be adverse effects of Scottish legislation on the rest of the United Kingdom, even if the bill in question is within competency. So there's quite a lot there, but the main point to get out of this in terms of Section 35, as we see it in the Scotland Act itself, is that it's the result of a compromise position that was brought by the Labour government at the time when it was enacting the Scotland Act. So at the time, there was a real question about how much power should be given to the Scottish Parliament. And there was an option to adopt as a test for competency, which is as a test for whether or not the Scottish Parliament could pass law, by reference to the test that's set out in Section 35, which is to do with whether or not there are adverse effects on UK-wide law. And that was deemed to be inappropriate as a test for competency because it would catch too much. It would be too easy to meet. Too often are circumstances arising when law might be passed that could have an adverse effect on UK-wide interests. And so the Labour government thought, that's too strict a test. It would unduly limit the powers of the Scottish Parliament. And so instead it adopted a different test for competency issues, which is focused more on the purpose of the act itself. And so that gives a significantly wider latitude to the Scottish Parliament. But the only reason why the UK government was willing to do that, the Labour government was willing to do that at the time, was if it had this reserved power in place that it could use in circumstances as have arisen now, where a bill might be within the competency of the Scottish Parliament, but would nevertheless affect UK-wide interests in such a manner that it would warrant UK intervention. So I think it's important to see how this test is designed effectively to be easy to meet, but politically to be rarely used. It's only supposed to be used in circumstances where the UK government feels it is justified in doing so.
So Section 35 was essentially a confidence giver that we're going to let the devolved government have all these powers because we know if it does something really crazy, we can stop it.
Yeah, exactly.
So we're wind forwards now 6 years to 2004, the next relevant piece of legislation for our purposes, the Gender Recognition Act. Maybe you could give us the context of that, why the UK government passed that act, and what it envisaged about the process of changing sex and who the individuals were, or what sort of issues they would be encountering when they decided to change sex.
Yeah, so this piece of legislation is quite interesting because it's the product of two very important developments in the UK at this time. The first is there had been a long-standing at this point for quite a few years. There had been protection for trans people in UK law under anti-discrimination law up until this point. So you couldn't be fired for being gender non-conforming. You couldn't be fired for going through a process of legal sex change. But what wasn't in place at that time was a legal mechanism whereby you could change your birth certificate. So often when we talk about something like, the Gender Recognition Act or the Gender Recognition Reform Act, we think we're talking about legal gender as something that's distinct from legal sex. And that's not true. The thing that is affected here, the legal concept that's relevant here, is legal sex. And the reason why this bill was first proposed and then eventually became an act, the 2004 Gender Recognition Act, is because there was a case at the European Court of Human Rights called Goodwin that was dealing with a post-operative transsexual woman who was biologically male, had been born male, and had gone through a significant process of changing her physical appearance and her driving license and her passport. There's certain things that you could do already under UK law to reflect a changed gender identity in law. But what wasn't available was a change to birth certificate. And so Goodwin sued the UK in the European Court of Human Rights, and the European Court of Human Rights effectively said, for specifically post-operative transsexuals, people who have gone through significant surgical intervention, not providing them with a birth certificate to reflect their now changed gender in law as a change in sex, would be a disproportionate interference with their rights. And so the UK government and parliament, in response to that, basically took that and went one step further. This was a monumentally progressive piece of legislation in 2004 because it provided not only for post-operative transsexuals to be able to change their birth certificate, but also those who could not or would not go through medical intervention in the form of surgery as well. And so what the Act does is it sets out a process whereby you can change your birth certificate and therefore change your legal sex if you meet certain criteria. So you have to apply to a specific specialist board, a gender recognition panel, and provide them with quite a bit of evidence. So the first thing you need to do is you need to be diagnosed with gender dysphoria. So you need to have this medical diagnosis that you have severe discomfort with your biologically sexed body and are on a process of doing something about that. And you would also have to live in your acquired gender for 2 years and provide evidence for that. And often as a part of this, the guidance for this, the evidence would include assessment of your doctor for how well you have lived in the acquired gender, how genuine this case is, things like that. And also important for our discussion here, you have to be over the age of 18 to do this as well. So this was, for quite a lot of people, this seems like quite an invasive process, or at the very least, it's an onerous process. It requires you to provide quite a lot of evidence. On the other hand, it was seen to be quite a progressive piece of legislation that provide for the first time a mechanism by which you could change your legal sex. And the point at which things begin to become controversial for later pieces of legislation is that one provision in the Act states that if you get a certificate from this body called a gender recognition certificate that allows you to change your birth certificate, you will have changed legal sex for all purposes. But then, two provisions down, it says, but of course we don't mean all purposes here. What we mean here is all purposes except where there has been exemptions or exceptions set out either in this Act or in any other piece of legislation. And in that Act, in the Gender Recognition Act itself, there were a whole host of circumstances where changing legal sex would not change your sex. And so some of those would include things like parentage. So if you gave birth to a child and you changed your legal sex to be male, you would still be classed as the mother of that child. You wouldn't be classed as the father. And other things to do with sex-specific crimes. If you've committed or been the victim of one of those crimes, the fact that you have a gender recognition certificate would not mean that the sex would change for those purposes. And so the question then comes is the provision that says that you will not change sex for all purposes if there are provisions of this Act or any other Act that alter that. The question that we kind of get arising as a result of that is whether or not further pieces of legislation, like, for example, the Equality Act, are affected by that.
Right. So essentially, the important things to note about this, or the process by which you get a gender recognition certificate, is medically supervised, and there is a set process. You have to live in a medically supervised way for 2 years in the gender that you're intending to change into, and then the second thing is the effect of that certificate and what rights or position it gives you and doesn't give you. So now we're going to wind forward 6 years to the Equality Act, passed in 2010. And in particular, maybe you could talk us through what it has to say about sex and discrimination, discrimination with regard to those who've had sexual reassignments, and then, single-sex spaces, in what way that they are allowed or not, and the ambiguity over how a transsexual or a trans person is included in those different things.
So the Equality Act is a consolidation of a whole host of other anti-discrimination statutes that had at that point been on the books as separate statutes in the UK for decades. So we had a Sex Discrimination Act, we had a Race Relations Act. There were other pieces of legislation that dealt with this. So the Equality Act consolidated all of those things together and then established a unified framework for dealing with anti-discrimination rights as a part of that. And so the main provisions in the Equality Act that be relevant here are, first and foremost, it sets out two separate protected characteristics. And what we mean by protected characteristics are the sorts of characteristics that matter for the provisions within the Equality Act, within anti-discrimination law and within equality law. And so the two that matter here are sex on the one hand and gender reassignment on the other. So sex was defined by you were considered to be a woman for the purposes of the Equality Act if you were a female of any age, and you were a man for the purposes of the Equality Act if you're a male of any age. So those are the definitions that are placed into the Equality Act. And so sex is then defined by reference to that. And other things like sexual orientation are also defined by that. So sexual orientation covers people who are attracted to the same sex, to the opposite sex, or to people of either sex. And so you see, even as a part of this, the legal framework seems to be tying, at least intuitively, would be tying to something like a biological category of sex rather than a legal one, because most people are not attracted to a legal category. When they're sexually oriented to something, they're oriented to biological categories, not legal categories. And gender reassignment as a protected characteristic. It's quite a long provision, and it catches significantly more people than those who necessarily will have gone through a process of sex reassignment under the Gender Recognition Act. Gender reassignment protects anybody who is in the process of going through, has undergone, or intends to go through a process or any part of a process of changing one's sex. So either physiological or other aspects of sex. So that has been interpreted now to include effectively anybody who would broadly fall under the category of trans or non-binary, potentially even people who might consider themselves to be gender non-conforming. It catches a significant amount of people because it triggers if someone is even in, contemplating or proposing to go through a process. They're not required to have actually be in the process of or actually have gone through a process of gender reassignment. And so the main provisions there that operate here protect people from wrongful discrimination on the basis of those protected characteristics, but also in relation to other provisions in the Act that we can get into as well, in terms of single-sex spaces or affirmative action policies. I don't know if you'd want to
maybe we'll do that later on, because I'll ask you how the situation would change under the proposed Scottish law. So for now, we can move on to our final piece of legislation, or would-be legislation, which is the Gender Recognition Reform Act, which the Scottish Government attempted to pass last week and is now paused. So perhaps you could talk us through, how does it propose to change the process by which you change your legal sex, what it means to get a certificate under this law, that would say, under, a Scottish certificate, or is it a UK certificate saying that you are the other sex? And then this idea of a statutory declaration that you have to make that you are now the opposite sex.
Yeah, so I think the first thing to bear in mind here is that the Gender Recognition Reform Scotland Bill and potentially Act, it doesn't just change the process by which you can change legal sex, it also changes the category of people who can change legal sex. So what it does is it removes pretty much all of the third-party verification processes that were set up in the original Gender Recognition Act to prevent people from changing their legal sex for other reasons that are not related to gender dysphoria. And it does that by removing the requirement that you be diagnosed with gender dysphoria, and also removing the requirement that you provide evidence before a panel that will make an independent judgment of whether or not this claim is a genuine or a true one, and removes the requirement that you go through a requirement to live in the acquired gender for 2 years, reduces that to 3 months for those over the age of 18, and 6 months for those under, and then lowers the age as well. And so, although basically what this is going to do is the process of obtaining a gender recognition certificate now will be, if this bill is passed in Scotland, will be that you make a declaration, a statutory declaration, that you have lived in the acquired gender, whatever that means, and intend to live in the acquired gender, whatever that means, for indefinitely, and you pay a small fee of, I think, £5, and then you will get your gender recognition certificate. So significant changes that are happening there in terms of the cohort of people who will be able to apply for and receive this, just as a pure matter of law, even without dealing with questions of fraud or whether or not people are going to lie on their declaration. And people who don't have gender dysphoria will now be able to change their legal sex. That's an absolute certainty. People under the age of 18 will be able to change their legal sex. So we change the substantive category of the people who can change sex as well as a part of that. And then there are additional issues that might arise in terms of whether or not the process for assessing this in terms of its validity or the truth behind it, whether or not there might be fraudulent applications, whether there's any concerns about that. But that is in some ways slightly separate.
I wanted to highlight one very peculiar aspect of this bill that you highlight in your paper, which is that it requires those who want to change their legal sex have to live as the gender they want to change into for 2 months. But it doesn't actually define what it means to live in the opposite gender. And the Scottish government didn't want to say anything that would potentially, make certain people angry, like you have to engage in stereotypical womanly or manly behavior. And the result is that they've simply left that empty. So there's no medically supervised process. No doctor at any point has to say, we, in our judgment, X or Y. And there's no other obvious external body that could verify any of this. And yet there's also a 2-year prison sentence in the bill if you fail to do what the bill tells you to do, without it having been defined. So I just wonder if you could explain, I mean, maybe you can't explain, but how and why this could possibly be the case in a piece of legislation, and what sort of ramifications that would have.
Yeah, I mean, I think drawing attention both to the substantive content of this, but also the fact that this attaches a 2-year prison sentence, I think that is really problematic in terms of both rule of law concerns and also potential human rights concerns, because of the vagueness of what this will require. So the criminal sentence attaches if you provide a false statement in relation to any material aspect of the declaration that you're about to make. And the intention to live in the acquired gender, it can only be a material aspect of the statement that is made, the statutory declaration. And you're right, the difficulty is that, and this is a difficulty that is in some ways still present within the Gender Recognition Act itself, but is mediated through both the doctor's role to show that there is a genuine case of gender dysphoria, and the panel's role of assessing the evidence that's been provided. So, but there is still an issue here, which is, what do we mean by living in the acquired gender? Do we require, for example, in order for you to demonstrate that you were living as a woman, for you to shave your legs or have long hair or wear makeup or wear dresses? And the answer is very probably under the original system, that if you don't do something like that, there may be concern. So, for example, if you had a beard, like I have quite a large beard at this point, it would be very, very difficult for you to convince a panel that you intend to live as a woman if you have a full bushy beard, or if you have no intention at all to do anything that might be classed as stereotypically feminine. Now that this has been, the third party verification has been removed, which means it's very difficult for us to think about what would it mean to live in the acquired gender separate from that medicalized process of someone who is deeply discomfortable in their sexed body, and how they might deal with that as a medical treatment, in terms of the way that this would have been operated under gender dysphoria in the past would have been in some ways to accept that this is partially a socially constructed category, in the sense that the people who are deeply discomfortable with their sex body may have to rely on sex-based or gender-based stereotypes in order to no longer feel comfortable. But now what we have is a system wherein you will be potentially sent to jail for 2 years if you lie about your intention. But there's no way for us to independently verify that intention, because it would be regressive for you to require somebody to wear makeup or dresses or have long hair. It will be incredibly regressive for you to attach any other social expectations about being a stay-at-home mother or not working in particular industries, which means the only option that's left, and it's the only option that Shona Robinson was able to provide in terms of providing evidence, is if you change your pronouns, which is to request other people to refer to you in particular ways, or you change documentation like driver's license or passport or things like that. So at that point, living in the acquired gender effectively means that you live in a legal status, and that legal status is only really manifest in things like legal documents or the social element of having particular pronouns. But even in that context, Jonah Robinson said, well, none of these would be, you wouldn't be required to do all of these. Any one of them would be sufficient. So it's either the case that it will be exceptionally easy to meet this standard, because living in the acquired gender is now simply living in a legal status, and the second you get your gender recognition certificate, you live in that status. Or the requirements will be so vague and amorphous that it will be very difficult for us to then identify circumstances where the where a prosecution could be brought, and particularly a prosecution that could be brought that could withstand human rights or rule of law scrutiny. Because if somebody was to be, I mean, I can't really imagine how somebody would be prosecuted for a material. Potentially, if they had bragged to all of their friends that they intended to lie about this, that might be some circumstance where it might be seen. But outside of that, I think it'd be almost impossible for a criminal prosecution to be brought underneath this.
And that's particularly significant because the Scottish government has repeatedly referred to this 2-year penalty as one of the safeguards for why this system wouldn't be wide open to abuse. But if on further scrutiny that totally dissolves, then it's not much of a safeguard, is it?
Well, absolutely. I mean, I think something that I find somewhat shocking about this is to say, you point to the fact that there are certain extremely unscrupulous people who are willing to break a whole load of laws. And you ask, how are we preventing those people from taking advantage of the system? And if the response is, well, a statutory declaration is a legal declaration, and that's really important, and most people would not go through that lightly. Well, we're talking about people who would go through that likely. And so the idea that there's a statutory declaration, if there's no mechanism to enforce that statutory declaration, if there's no mechanism to verify that it was true, then relying on the good conscience of unscrupulous criminals and rapists is not going to be the best way for you to get around the issue that there's no independent mechanism for verifying the truth or the fraudulence of these statements.
Yeah, and the Scottish government even had an opportunity to explicitly exclude one category of people who we might be worried about, i.e. people who have an offence or on this recorded offence, sexual offence, or on the sex offenders register. There was an amendment put forward to say this category of people should not be included as eligible in this legislation, and it was rejected by the Scottish government.
Yeah, there were two actually. So one of them was this one, and initially that was introduced when it was introduced at stage 2. The provision effectively said it was a blanket ban. If you're on the sex offenders registry, you simply cannot change your legal sex. And I think it was probably quite right for the Scottish Parliament to say a blanket ban like that is probably disproportionate. You could probably run into human rights problems there. But it was then introduced again with a qualifier that said, okay, you don't have an automatic right if you're on the sex offenders registry to go through this process. You can go through a different process. You can appeal that and demonstrate to an independent panel that this is a genuine case. That seems to me to be a way to have resolved that issue, and that was voted down as well. In addition to that, though, there was also a requirement or a proposed amendment that would require there to be a pause on the ability to obtain a gender recognition certificate if you were currently in the process of going through a criminal conviction for sexual assault. And so what that would mean effectively is if you have been accused and are in the process of a criminal trial for sexual assault, you cannot change your legal sex until that has been resolved. And the reason for that would be to prevent female victims from having to refer to their rapist or their assaulter by female pronouns, to refer to them as she. And it seems to me that would be one way to alleviate some of the concerns in relation to the dignity of these victims without having any permanent ban on the ability to change your legal sex. You could just do it after the prosecution has been resolved. And that was also voted down. So these amendments were just not introduced. And the UN Special Rapporteur on Violence Against Women and Girls specifically intervened in this matter before the bill got through to stage 3 and also after the bill was passed, to say that there just simply are not adequate safeguards here to prevent abuse of this system by violent males who would then put women and girls at risk.
So now I want to talk about what it would mean under this legislation to change your sex. And what the possession of a Scottish certificate would mean. And in particular, there's a bit of a legal minefield here for the Scottish government because, and that's because of a reserved power. So under the original Devolution Act that we started with, equal opportunities is a particular policy area where the Scottish government is not allowed to make legislation. That has to be uniform for the whole UK within the purview of the Westminster government. And therefore, the Scottish government has been in a bit of an ambiguous and tricky situation saying as to what exactly it would mean to change your sex under this legislation. So on the one hand, it's said that This is a minor bureaucratic matter, as you say in your report. It's just a formality, and having this certificate would not give you potentially all these extra rights or potential access to spaces under the Equality Act. On the other hand, in other situations, the Scottish Government has implied that it would do. So could you maybe talk us through what that means, why it's important, and what actually the legislation says, what's right?
Sure. So, I mean, I might start by pointing out just how serious the ambiguities are in relation to the legal effect that this bill will have. And the first one is to note that the 2004 Gender Recognition Act, at the time that went through, it was accepted by both the Scottish Government and the UK Government and a number of interveners that were intervening in the case, including anti-discrimination and equality-based charities, that gender recognition is not fully devolved. It touches upon both devolved and reserved areas. And it was submitted by the equality charities that the impact that this would have on anti-discrimination legislation and equality legislation would be reserved to Westminster, and that was not challenged by any of the governments at the time. So although the general idea of a legal sex change would be considered to be devolved, there are parts of it, there are aspects of it that have always been understood to touch upon reserved matters that are reserved to Westminster. And so that then raises some interesting questions about what the legal implications are going to be for a bill of the Scottish Parliament that proposes to change some of the provisions in the Gender Recognition Act. And part of the difficulty here is, first and foremost, there has been for a very long time ambiguity about the interaction between the Gender Recognition Act of 2004 and the Equality Act of 2010. So both of those are UK-wide, or they're acts of the UK Parliament. So these are not devolved pieces of legislation. But it really wasn't clear for a very long time whether or not a gender recognition certificate will change your sex for the purposes of the Equality Act. We weren't really sure about that. We had legal arguments on both sides for a very long time. And about 7 days before the final reading of this bill, a case was decided in the Scottish courts, which came to the conclusion that changing your legal sex and obtaining a gender recognition certificate will change your sex for the purposes of the Equality Act. And the reason why they came to that conclusion is because the Scottish Government argued for it. So this was a successful claim by the Scottish Government in the Scottish courts that this is the legal effect of obtaining a gender recognition certificate. And the issue is that if that's true, as the Scottish Government has argued, then some of the claims that have been made by Scottish ministers in Parliament, in the Scottish Parliament, just don't seem to be true. If it's true that you change sex for the purposes of the Equality Act if you obtain a gender recognition certificate, then it's simply false to say that the Equality Act will not be affected. And it's simply false to say there'll be no impact upon schools, because these will manifestly change as a result of this bill. And so the difficult question that we're asking here is, first and foremost, what will the legal effect of obtaining any gender recognition certificate have for the Equality Act? And then secondly, whether or not it'll be different between the rest of the UK and Scotland. And so the first of those questions is resolved by this case that says, if you change your legal sex for the purposes of the Gender Recognition Act, by virtue of getting a gender recognition certificate, that will change your legal sex for the purposes of the Equality Act as well. So that's been resolved. And then the second question, there's real ambiguity there as well, because at some point the Scottish Government is arguing that obtaining a gender recognition certificate, the certificate that you will get by virtue of the Scottish process, will have the exact same legal effect as a UK-wide gender recognition certificate. And it's not clear at that point whether or not when they say exact same legal effect, they mean it will be automatically valid for the rest of the UK, or whether or not they will need specific provisions from the UK lawmakers to recognise them. So at one point they're saying it will be up to the UK government to decide whether they want to recognise these certificates. But at other points they're saying that they won't need the UK government's approval at all. And in fact, if the UK government tried to stop this, it would be a direct assault on the Scottish Parliament's lawmaking powers, which is frankly quite strange, considering what they're effectively saying is the Scottish Parliament should be able to change the legal system for the rest of the UK unilaterally, and it would be an assault on democracy if the UK decided, well, nobody in Wales voted for this, so maybe we should have a say over that.
Right. So what we seem to be seeing is a pretty barefaced, politically convenient description of the law. So on the one hand, where it's convenient for the Scottish government to argue in court that this gender recognition certificates do have all these implications, and that it is, marching in a progressive direction for the purposes of the Equality Act and opening up all sorts of rights to new categories of people, then it will say that. But on the other hand, when it doesn't want to run into the legal minefield of going beyond its powers, i.e. suddenly doing something that affects equal opportunities, that explicitly treads on the territory of the Equality Act, then it says, oh, no, this is just a formality, which seems to be, to put it mildly, in slight bad faith.
I don't know if I'd go so far as saying that it's in bad faith, but I will say that the Scottish government had been warned about this multiple times, both from equalities campaigners, women's rights groups, but also the Equality and Human Rights Commission, which is an independent public body designed and set up to ensure the smooth running of equality law throughout the entirety of the UK. And they intervened multiple times, sending repeated letters to the Scottish Parliament and the Scottish government saying that there are serious cross-border implications that need to be addressed here. It's really not clear how this bill is going to interact with the operation of the Equality Act in the rest of the UK, and this needs to be resolved. And the Scottish government seems to have responded to that, firstly by, I think, in some ways downplaying these indications. We've seen Nicola Sturgeon saying in an interview even this week that although she had been told about these, she has not heard any persuasive arguments for why there might be a change to the operation of the Equality Act. So it would be unclear to me to know what would be required in order for those arguments to be persuasive. But also, you have put onto the face of the bill a claim that nothing in this modifies the Equality Act. And you might think, oh, well, that will resolve all of the issues. But there's two reasons for why that wouldn't. One of those is, the face of the bill could say that the sky is green, and they wouldn't make the sky green. But secondly, there's nothing in this bill that's going to modify any of the provisions in the Equality Act, in the sense that it will not repeal or replace any of the provisions of the Equality Act, but it will change the way the Equality Act operates, because it's modifying the Gender Recognition Act as it applies to the Equality Act. And so although you're not changing any of the provisions in the Equality Act by modifying them, by removing them, or by replacing them, you could still nevertheless change the way the Equality Act operates by fundamentally changing the category of people who can change sex for the purposes of the Equality Act, and making it significantly easier for people to do that, and removing all third-party verification to prevent fraud.
So I'm going to move on in a minute to talk about the effect of this on single-sex spaces. But before I do, perhaps briefly, you could explain the issue of that some have talked about, of gender tourism, that effectively, although this is only meant to affect Scotland, someone living in England or Wales or Northern Ireland could potentially go to Scotland to get their gender changed, and then go back into the rest of the UK and use that certificate in some way or another. So is that true? Because the Scottish government claims it's not.
Well, I think it depends on what the implication of getting one of these certificates is going to be, and we really don't know that at this point. That's the real issue, is that we just don't know what the legal effect of having one of these certificates is going to be for the entirety of the UK. So the bill itself states that you can get one of these certificates if you were born in Scotland, if your birth is registered in Scotland, or if you are resident in Scotland. And so the resident is the part where there might be an issue of gender tourism, because the certificate will be issued to you if you, for example, move temporarily to Scotland such that you become resident, and then can do that. The question is whether or not these certificates will change your birth. So if you are able to use one of these certificates to change your Scottish birth certificate, then it won't really matter if the gender recognition certificate is not recognised outside of Scotland, because birth certificates are recognised outside of Scotland. And so there could be practical implications here, in the sense that if you change your Scottish birth certificate in Scotland, if the UK government refuses to recognise the gender recognition certificate, but for many, many practical purposes, it will recognise a birth certificate, let's say if you're applying for a single-sex school and you have to provide some documentation to prove that you're of the sex of the school, something like that. But the other concern in terms of whether or not there might be tourism here would be if getting a Scottish gender recognition certificate will be valid to change a birth certificate in that is registered in England, Wales, or Northern Ireland, or something like that. So you could have circumstances where that could happen, but we really don't actually know. The UK government, in its statement of reasons for why it has blocked the bill, is of the view that it simply is not within the competency of the Scottish Parliament to create a bill that would allow for a change like that would be automatically valid in the rest of the UK. And you can see where there might be very strong reasons for accepting that. The other alternative view, which I set out in the Policy Exchange report, is that the change to the Gender Recognition Act only changes the criteria within which you can get a certificate, but the certificate remains the same certificate across the entirety of the UK. And it seems like that might have been what the Scottish government thought they were doing when they said the legal effects of getting one of these will remain the same, because one of the legal effects of getting a gender recognition certificate under the UK Act is that you change your legal sex for the purposes of UK law.
Right. So on that very topic, what would be the effect of this? I mean, you've said it's slightly unclear. So this question hinges on whether the Scottish law would affect your rights and obligations under the Equality Act. And as you describe in the paper, the Equality Act doesn't actually give you the right to a single-sex space. It just means it allows you to discriminate so that you can create a single-sex space for various lists of reasons that it sets out. And so would this law, if it were passed in Scotland, would it potentially affect the ability, say, of a shelter or a prison or a charity to be able to exclude someone who had a gender recognition certificate issued in Scotland? Or not? So would it fundamentally affect their ability to maintain single-sex spaces on a biology basis?
So I think that the first thing to note here is that the ambiguity that exists on this point is whether or not the changes that will come in will be confined to Scotland or whether they will extend outwards. So we will know that if the bill does what it purports to do, it will change the operation of the Equality Act in Scotland at a minimum. And we're unsure at this point whether or not it would change the operation of the Equality Act in the rest of the UK. But the Equality Act is tied to a reserved matter, which means it's not open for the Scottish Parliament to interfere too strictly within the operation of the Equality Act, even in Scotland. So this is probably within the competency of the Scottish Parliament, because the test for competency gives a significant amount of latitude to the Scottish Parliament, but whether or not it's enough to trigger a Section 35 order is a separate point. So in terms of the single-sex spaces, services, things like that, I think I'll start by just setting out the position in Scotland, because that's the one that we know will change. And then you can just add on to that, this might be the case for the rest of the UK. So the Equality Act distinguishes between single-sex services, single-sex associations, and single-sex schools. So for services, these are services where there's a provision of a service to the public, either for free or for payment, but is generally open to the public and provides something in the way of a service. So this will catch most of the things that we tend to think about when we're thinking about single-sex spaces, things like changing rooms or toilets or domestic violence shelters or prisons or things like that. These are predominantly going to be classed as services. And in this context, the legal test is going to change here, because getting a gender recognition certificate will change your legal sex and will change the way the tests operate at a very technical level. But in practice, the legal test will remain broadly the same in terms of if you run one of these services, let's say a domestic violence shelter or toilets or changing rooms or things like that, the law will broadly remain the same in the sense that you will be permitted to set up these services and you will be permitted to exclude on the basis of either sex or gender reassignment if you have an objective justification for doing that. So the actual legal rules will remain broadly the same for services. The difficulty that will arise will be in terms of the practical implication or implementation of those tests, which will mean that there might be some circumstances where, because the law is so unclear in most of these areas, that services might decide that it's just not worth the hassle of being sued for setting up one of these services in a particular that is, sex segregated in that sense. There might be a concern for services where you could indirectly discriminate by failing to provide a single sex service. So there's currently litigation happening in Brighton with regards to a rape crisis shelter that does not provide separate services on the basis of biological sex. And the litigation is effectively saying this is indirectly discriminating against women who are victims, and also there's an argument that could be made there as well that this would indirectly discriminate on the basis of religion, because it would result in people self-excluding from these services, and so failing to provide that space on a biologically segregated or separated manner might result in there being a particular disadvantage for particular groups of women, most notably victims of assault and Muslim women as well, or those who have religious convictions that require them not to spend or to share intimate spaces with biological males. Broadly speaking, services legally are not going to change much, but practically might.
Right,
The issue really that's going to arise here.
And that's because the bar for proving that you have a legitimate reason to exclude a particular category of people might be raised, or that you could be sued more easily potentially, or because there's more people around trying to make this claim, and therefore your risk of being sued goes up.
Yeah, so there's an increased risk just because there might be more people trying to have access to these spaces. As a practical matter, that could happen. There's also an increased risk in the sense that although the legal test will broadly be the same, there will be a practical difference between, let's say, someone who's operating a changing room or a domestic violence shelter. There is a difference between excluding a biological and legal male who is covered under the gender reassignment characteristic. There will be a test for that, and there's there's a difference between that and excluding someone who is considered to be a legal female on the basis of their gender reassignment. So from the perspective of the law, in one of these, this is a man trying to have access to a service that's designed for women, and there has to be good justification for excluding that person. But from the perspective of the law, if you've got a gender recognition certificate, then you're a woman trying to have access to these services. And so the reason for setting up a women-only service will be called into question if you're refusing access to legal women. So there could be practical implications for how those tests are implemented in regard to that, particularly if the category expands not just in numbers, but also in terms of if you have people who are classed as legal women who have gender recognition certificates, who are biologically male, who do not have a diagnosis of gender dysphoria, and do not have any requirement to live or act in a particular way. So you could, it wouldn't be completely unfeasible to imagine, for example, a very tall, bearded, biological male who has a gender recognition certificate stating that they are legally a woman, demanding access to certain female-only spaces. And so the practical implications of this, having a gender recognition certificate, could be relevant here, even if the nature of the legal test remains broadly the same.
And just to do one more category before we move on to my last question, which is schools. So schools suddenly are at play if this reform passes, because it lowers the age from 18 to 16. Is that correct? And so for that slice of the school population, people in sixth form, suddenly it potentially opens up the possibility that single-sex schools are no longer single-sex on a biological basis.
Mm-hmm. Yeah, so this is true for both schools and associations. So they're dealt with differently within the Equality Act. So an association would be something like a private club or a walking group or a reading group or something like that. And schools, we know what schools are. But schools and associations are subject to different rules under the Equality Act. So for single-sex services, the rules effectively allow you to discriminate if it's justified on the basis of both sex and gender reassignment, which means whether or not you change your legal sex is going to have practical implications, but legally speaking, there's still provision there for people to be excluded. Associations, which if you have more than 25 members and you in some way regulate the membership, and schools don't have that exception. Schools can only discriminate on the basis of sex if they are single-sex schools, and the same is true for associations. They can only discriminate on the basis of the characteristic that they are set up for, which means if somebody is legally female but biologically male, their exclusion from one of these schools or associations will not be because of their legal sex. It will be because of their gender reassignment characteristic. And there's no provision in the Equality Act that permits schools or associations to discriminate on the basis of gender reassignment, which means there will now be a legal right of access to gender recognition certificate holders for associations and schools. And so for associations, that's going to cause that's already an issue that's there, in the sense that it is already the case that having a gender recognition certificate would grant somebody a right of access. But that the vast majority of associations are not going to have to deal with this because there are so few people with gender recognition certificates. But that will change under the Scottish bill. It will become much easier. And so I've seen testimonies in the news recently about people who run, for example, a women's only walking association. So they've got a large group of women who go for hikes and walks, and they do that because they just want to hang out as women. And those associations will now be subject to a heightened possibility or likelihood that they may be required under law to admit somebody who is biologically male but legally a woman into their group. And so it will be illegal for them to exclude in that context. And schools, this is where things get much more difficult for schools, because in school, the 2004 Act that set up the legal mechanism for changing your legal sex, it just was never envisaged to apply to minors. And so the school system is going to be affected much more directly here, which is that if you have a single-sex school, but even if you don't have a single-sex school, a mixed school will also have to deal with concerns here. Single-sex schools will not be allowed to exclude a gender recognition certificate holder with the legal sex that matches their sex, for the same reason that associations can't, because it would be direct discrimination on the basis of gender reassignment, and that's not permitted under the Equality Act. But there will be additional concerns for schools, even if you're dealing with mixed schools, because one of the provisions in the Gender Recognition Act, which again was not designed to apply to minors, is that if you have a gender recognition certificate, it becomes a criminal offense for somebody who has access to information that you have changed your legal sex to disclose that information if they've come across that information in an official capacity. So it's a crime for somebody to disclose that information. And so that information includes not just the fact that you have a gender recognition certificate, but also the fact of your biological sex. It becomes protected information. Now, if that applies to schools, wherein let's say an administrator in the school or a safeguarding coordinator in the school has come across the fact that some of the pupils that are registered on the school registry as male or female are actually biologically the opposite sex, it's a criminal offense for them to disclose that information to other teachers, to students, or to parents. And that would then create serious concerns for safeguarding in circumstances where, let's say, a teacher is not aware that one of their pupils, although classed as male, is legally male but is biologically female. If that teacher then takes those students on a class trip and decides who's sleeping in what room, they could end up putting a biological female into a room full of biological males, or vice versa. And that's ordinarily just not something that you would consider to be appropriate for a safeguarding perspective, even if we don't think there's going to be a massively high risk of assault or anything like that. The main issue with this is that Safeguarding 101 is built on the idea that you do not keep secrets. And this requires you, on pain of criminal sanction, to keep certain quite relevant information secret.
Okay. I'm going to ask you the last question. We've really run on a lot, so let's. No, it's okay. I mean, it's incredibly thorough, and we've really covered a huge amount of ground. But the last thing I want to ask you is there anything the Scottish Government can do to change this legislation to make it legal to get it through from your point of view? Or potentially another thing that some are talking about is that, maybe the government in Westminster could change the Equality Act to define sex in a biological way, and maybe that then, would have a sort of knock-on effect on Scottish legislation, which perversely might let it through or make it easier to go through. But essentially, I want to ask, what can the Scottish Government do if it's determined to get this bill through?
So it seems like in the statement of reasons that the UK government gave, although its reasons spanned quite a lot of concerns, the majority of concerns that they're identifying are relating to the effect that this is going to have on the operation of the Equality Act. So if you remove the effect of gender recognition certificates in general on the Equality Act, or Scottish gender recognition certificates in particular on the Equality Act, you remove all of the concerns, or at least most of the concerns that might be identified by the UK government. And so this could either be done by the UK government choosing to pass an amendment to the Equality Act to say that that sex for the purposes of the Equality Act is biological sex and does not include gender recognition certificate holding persons of the opposite biological sex. You could also have an amendment made by the Scottish Parliament that says that although this permits you to change your legal sex for the purposes of Scottish law, it does not permit you to change your legal sex for the purposes of UK-wide equality law. That could immediately resolve the issues. There might be some concerns there about what you deal with, how do you deal with birth certificates, whether or not the effect of having a changed birth certificate will expand. But that could easily be resolved, I think, in negotiations. And in fact, I mean, what that would do then would be, if you had a change here that permitted you to change your legal sex for the purposes of getting married in Scotland, dying in Scotland, or changing your birth certificate in Scotland, that would do effectively what the Scottish Government was claiming the bill does no more than. They've been claiming for a long time that this is just a minor bureaucratic change that allows for certain things like marriages, deaths, and births to be recorded in the acquired gender. Then that would resolve most of the issues. And the issue is that it seems like, because of the way the Scottish Government has argued in court about the effect that gender recognition certificate should have for the Equality Act, that it may not have wanted to just have this minor bureaucratic change, that it wants to have significant changes to the operation of the Equality Act as well. And so one of the ways that the bill could be amended here is to just reduce it to what the Scottish Government said it was going to do all along, and explicitly set out not just that this will not modify any provision in the Equality Act, but it won't affect it at all. So that's absolutely one way that they could do that. The political question is whether or not that's what they want.
Great. Thank you so much, Dr. Michael Foran, for explaining us, giving us chapter and verse on this very legally complicated and controversial issue. Thank you to all of our listeners and watchers for tuning in, and we'll see you next time on the Agenda podcast.